And we proceed to our last case today, which is Millar versus Construction Code Authority.
Mr. Chief Justice.
Please. I thought they were here for your case. Why not? Please proceed.
May it please the Court. My name is Rebecca Klipfel. I'm here representing plaintiff applicant Bruce Millar, and we have a much simpler issue for you this afternoon, which is, as this court has asked us to address only today, whether Mr. Millar's Whistleblower Protection Act count was barred by the statute's 90-day limitations period set forth at MCL 15.363, subparagraph 1. And the answer to that is unequivocally and undoubtedly no. The claim was timely filed 87 days after the occurrence of the alleged violation of the Act. The alleged violation of the Act occurred in the simultaneous first, last, and only attempt to effectuate the work restriction at issue and to communicate that restriction to the plaintiff, Mr. Millar, on March 31st, 2014. His suit was filed timely 87 days later. Now, the lower courts have permitted the defendants to avoid answering this count in reliance on dates on the faces of various writings issued by them. And at risk of being redundant or repetitive, because there seemed to still be some confusion about this issue at the Court of Appeals level when we did our oral arguments there, I find it's necessary to reiterate that no defendant at any time has ever alleged any alternate set of facts, because none exists. Aside from a brief and truly bizarre colloquy before the Court of Appeals, which I won't permit to distract us at this moment, no defendant ever alleged that any communication was attempted to Mr. Millar of these restrictions prior to March 31st, that any writing was mailed to him, emailed to him, telepathically communicated to him, or in any way any attempt was made to effectuate these restrictions. And you will see that in the affidavit that he submitted in opposition to these summary disposition motions, he made very clear that he not only was unaware of these restrictions until he asked on March 31st why he was not being sent back to complete the projects he was at within the subject jurisdictions on his last regular workday, March 27th, 2014, where he worked through the close of business on that day. Before March 31st, he had been regularly working within the subject jurisdictions. So this leads to another aspect of the lower court's holdings that is particularly egregious and absurd. Relative to the city and township defendants, the lower courts held that the time for Mr. Millar's claims against them began to run on the dates of their own letters to the Construction Code Authority expressing their wish that Mr. Millar no longer be sent to perform inspections within their jurisdictions. Now, at the same time, the lower courts correctly held that Mr. Millar had established as a factual matter, which no defendant ever challenged, that they overlapped such that they were one and the same and alter egos for the purposes of his employment claims. So the result we have with the trial and the Court of Appeals holdings is that an employer can both avoid conspiracy liability by admitting that it's one and the same and alter egos with its co-defendants for the purposes of an employment claim, but that it can also harken back to some earlier date for the claims against it to run based on what's effectively an internal communication among the defendants. So that's just logically quite preposterous.
You know, you started your argument by using the word occurrence, and that is actually from the statute.
It is.
And so what does an occurrence, in order for a termination to occur, for there to be an occurrence, does it always require the plaintiff to be told? What if there's an internal operating procedure that defines how someone is terminated? And the employee goes home on Friday, complaint's made to a supervisor, the supervisor follows the procedure that the company has and puts a letter in the employee's box. And when he comes in Monday, the letter that was written Friday, and the decision was made Friday, is received by the plaintiff. Didn't it occur when they decided to fire the employee under the circumstance I gave you just now?
Particularly with respect to such a short time period intended to protect the public interest, I think that the occurrence could not happen until some effectuation of the restriction at issue and communication of that. And we don't have the facts that you just described in this case.
I understand. I'm trying to give meaning to the word occurrence, and I understand you want us to conclude that the occurrence didn't happen here until there was a communication. And I'm wondering, do I change the statute if I always require a communication to the plaintiff? Because I can envision some circumstances where an occurrence happens.
I don't think,
without the employee actually being given notice of it. It actually occurs, and then they become aware of it.
I don't think that that could be the triggering occurrence, respectfully. And my understanding of this is consistent with the current state of jurisprudence of this court as set forth, for example, in Comerica Bank, which I cited at length in my papers, where this court held that the notice to the plaintiff was the key factor in triggering the limitations period at issue there under the Elliott-Larsen Civil Rights Act.
Is constructive notice appropriate? If I mail the letter on Friday and Monday is a holiday and the plaintiff doesn't receive it until Tuesday, is it still notice at the time I put it in the mailbox?
Again, that's not at issue in this case because it
But
did
I'm
not
asking,
happen.
we're trying to understand the meaning of the word occurrence in the statute.
Well, in the Comerica case, again, the cause of action was deemed not to accrue, and then accordingly, of course, the time to file suit did not begin until the plaintiff was aggrieved, and she was not aggrieved, according to this court, when she knew that she had been suspended indefinitely from her job. But, and they distinguished the case in Parker, because in Parker, those folks knew on the last day they worked that their employment had been terminated and that they were discharged as employees on that date. Whereas in Collins versus Comerica Bank, which is at 468 Mich. 628, at page 633, this court pointed out that plaintiff in that case, Collins, knew only that she had been suspended on the date on which the defendants would have had the time begin to run. So this court has held, and this remains the current jurisprudence in this state, that notice is a key factor to a termination cause of action beginning to run.
Let me ask it this way. What is the relevant action that occurred on March 31st? Was it your client getting the letter that day or not being permitted to do any work in Imlay City that day? What was the occurrence on that day?
It was all of those things. They all occurred simultaneously.
So occurrence means both when the client is notified and...
In this case, yes, because they were simultaneous. So
But if I'm asking you to pick, what do you think is what as between those two things is the occurrence that triggers the statute? I know they're simultaneous. So you're saying that. So
I don't know as this court would have to pick or that I can. I just can't fathom that any earlier point in time could have triggered this, because let's say Mr. Millar had been working on other sites as he did at this job, or been out ill or on a vacation, or otherwise not as conscientious as he is, and hadn't asked that day, what's going on here, why aren't I getting sent back? Could Construction Code Authority have waited for his supervisor to have returned on April 7th, which is on the face of the letter that was delivered to him, that the board president had this terrible task put upon him to inform Mr. Millar of this decision, and clearly he was dragging his feet in doing it. What if Mr. Millar had come back 30 days later, 45 days later, 89 days later, and said, why am I not being sent back to finish this project in Imlay City? And they had pulled out the letter then and said, well, here's why. And your time began to run on March 27th. And that's pretty much the defendant's position here. And it's so contrary to the public interest and so clearly erroneous that I'm asking the court to not only grant our application for hearing, but to do as it did in the Smith versus City of Flint case, and indeed remand to the trial court with the finding, because there is no factual dispute here, that this count was timely filed.
If he's terminated, if he goes to Imlay City to do some work and someone from the city comes and says, get out of here, I don't want you working here anymore, you're finding too many technical violations, go back where you came from, we don't want you. And then Imlay City communicates on Monday to CCA, and CCA does a letter dated Monday and gives it to him, you're not going to be working in Imlay City anymore. When's the occurrence?
It can't be before he was stopped from going to work on that site and became aware that he had any cause of action at all.
Is it Friday or is it Monday?
It's Monday. But again, the facts of this case don't require...
No, you want to talk about the facts of this case, but we're trying to interpret the statute to apply in the future.
In the next case, we're going to have Friday, Monday. We just, right. In your case, it's easy because we have Monday, but in the next one, we're going to have Friday, Monday. So what do we, if we had to write an opinion, what would the rule say?
It can't be from the time a decision is made, but not effectuated or communicated to the plaintiff.
So you want us to say, we don't know what the rule is, but it's not this.
Well, the very clear rule is that this event occurred the one date that he was told not to go back to work on that site and was hand-delivered notice that he was not to go back to work at these sites.
You would agree that occurrence suggests action by the employer, right?
Yes. And those actions occurred on March 31st, 87 days before the lawsuit was filed. I don't think the occurrence can be that a decision was made that was not effectuated or communicated to the person who would have the claim. And again, if you look at his affidavit, Mr. Millar was working on those sites through the close of business on March 27th. I'm sorry, but I'm going to have to get a drink of water.
Yeah, that's okay. I could use one myself.
Sure.
Is it your argument, counsel, that the communication is significant largely because it provides a clear black and white time that we can assess for when the statute of limitations begins to run? Or is it that you really see a much more close connection between the violation or the occurrence, both of which seem to me to be the statutory starting point? And I don't see any particular logical relationship between the occurrence or the violation in the time of communication. I only see the communication serving some convenience sake, some convenience purpose, in that we can determine it with greater precision and certainty than we might in some circumstances, perhaps in this circumstance, when the actual metaphysical violation or occurrence has taken place. Do you follow what I'm saying?
I'm afraid that I don't exactly follow what you're saying. I can tell you...
Well, what is the logical relationship between the communication and the violation? I'm not sure I see the logical connection there. Once again, I do see the convenience of using the communication time as a basis for determining the onset of the statute of limitations, but I see no other logical connection between those concepts.
Until you tell the plaintiff that his work duties are being restricted, and in this case, simultaneously effectuate the restrictions, there can't be an occurrence that triggers the time for his count to run, to which he has no access or ability to know. We seem to be looking at whether this occurrence is the defendant's making a decision to take this certain action. That just seems to me nonsensical, impractical, and effectively a defense to any cause of action being brought, as long as the decision isn't effectuated or communicated to the would-be plaintiff. And I think that the Collins versus Bank of America or Comerica Bank decision highlights this. The occurrence here was the termination, which is the same as in our case. There's been all this reliance on Joliet versus Petoniak, which is another decision of this court, which I think does provide a good illustration of the difference when it comes to an occurrence, because in that case, this court told the plaintiff that in a constructive termination case, he could not begin his time to run his suit to be filed from the date on which he threw up his hands and said, I am constructively terminated, I can no longer work here, all right, which is the employee's action, but rather the time began to run when the violative act occurred, that is when the employers took whatever offensive actions they were against him. And that makes sense. And that's consistent still with my position here for Mr. Millar. The occurrence
Okay, your time is up.
is employer-based.
Further questions? Okay, well, thank you. Thank you, counsel.
May it please the court, Mary Massaran, on behalf of all the defendants with me at counsel table, our co-counsel Nancy Dumbinsky and Stacy Belisle. In the interest of conserving time and allowing for a better flow of argument, we've agreed that I'll argue on behalf of all of the co-defendants. The Court of Appeals reached the correct result here because the statute grounds the timing of the trigger for the limitations on the occurrence, not on the timing of the notification or notice. There is no notice provision in the Whistleblowers Protection Act. And it provides that a person has to bring their civil action within 90 days after the occurrence. This is a legislative policy choice to focus on the time of the employer's wrongful act. And if you look in this record, as well as in the plaintiff's complaint, the time of the wrongful act was, and you can see this in the attachments to the plaintiff's complaint as well. That is, each defendant in writing said, this, Mr. Millar is not to work in this city, in this township, and then the authorities saying, you're not going to be working in these locations anymore. So if there was a wrongful act at all, it would have been at the time that each of those letters were written and signed. And that's exactly what the plaintiff's complaint alleges in paragraph 16C, 17A, and 18 with respect to each of the individual defendants, that the wrongful act was the writing of these letters, which had a legal operative effect, according to the plaintiff's theory, of amounting to a discharge. Based upon that, the occurrence was at the latest on the 27th and not before.
So I see your point, but I'm concerned. What happens if, in a case like this, the city and the township communicate to the CCA, we don't want him, he's finding too many violations of law, keep him out of our jurisdiction. And the CCA drafts their letter, they get the letters from the township and the city, and then they get some work from other areas that he's worked in before, and there's no complaints, send him off to work there. And the 90-day period passes, he never gets the letter, never aware of it. And then that work that was generated is gone. It says, hey, how come I'm not going back to MLA City anymore? Oh, they canned you. They don't want you around. No, there's no cause of action?
Trentadue says no. Trentadue says it's not a violation of due process, and the statute can expire before the individual knows of the violation. That's what this court said in Trentadue.
So what if they write the letter and then they don't deliver it, but they change their mind and they let him keep working, but then he finds out about the letter within the 90 days? Doesn't he still have a cause of action?
Well, where's the harm if they've changed their mind? I don't know. I mean,
well,
I don't know
if the occurrence is, well, maybe there are no damages, I guess, but if the occurrence is the writing of the letter.
Certainly that would be the occurrence. That's the wrongful act.
But he just finds the letter. They change their mind, but he finds the letter later. He has a cause of action? He
doesn't have a cause of action. He doesn't have a cause of action because the occurrence was more than 90 days. He also doesn't have a cause of action because they're probably, in the event they've changed their mind, I don't think you could satisfy the other elements to establish a claim.
So the legislature's made a policy choice that we're going to be really tight with these and it's going to be 90 days. What if the same hypothetical I gave you, CCA says, and let's not let him know because we don't want to get slapped with a lawsuit. The city and the township clearly said they don't like the way he's doing business because he's following the law. So send him somewhere else and, make sure he's busy for 91 days. Now what?
That's a hard set of facts, and
all the cases that come here are hard.
I understand, believe me. Certainly the statute would say the cause of action has expired, and that's what Trentadue does. Now the question would be, in the event of some effort to defraud or circumvent, whether there's some other common law remedy. And I'm not sure of the answer to that. I know that there are fraud cases and other kinds of cases that might conceivably be available in that circumstance. I think it's important when we think about occurrence, this is not the only time when there can be an occurrence where the person who is hoping to recover isn't aware of it. If you think of the use of that word in the context of insurance coverage, for example, if you have a fire insurance policy and your house burns down and you happen to be living in Europe or Florida or someplace and you don't find out about it, there's notice provisions in those policies, and the occurrence is when the building burned down. The same thing is true of auto policy. So when the legislature uses a term like occurrence, which has a certain meaning, focuses on the act, it seems to me it's incumbent on the court to apply that as the lower courts did here.
So I'll throw you a softball. This is a MOA. We're just here to decide whether to take this case or not, right? And
Correct.
we don't have any fraud in this case. The plaintiff knew about it and had plenty of time, but just didn't bring it within 91 days. Might have been within 90 days of the time that they were made aware of it. But once they were made aware of it, they saw the dates on the correspondence and still had plenty of time and just didn't bring the cause. Right?
That's correct.
The softball. I got it.
That's correct. And I think that does make this an easy case, and one in which the court might well choose not to write an opinion and simply deny leave and leave the Court of Appeals rulings standing. I would suggest also...
Can I ask, I have a hardball. a lot of metaphors percolating around this room today.
I've been listening.
None of them are apt,
Very
but
impressive lawyering.
My hardball is, what do we do in the next 100 cases?
I do think the body of case law that is out there now is very, can be readily harmonized on the basis that the court has said with respect to Joliet, with respect to Collins, with respect to the various cases, that you look at the employer's wrongful act, okay, and they arise in different circumstances.
It just can't be the rule that the triggering point is something within the control of one party, and he or she or it has the power during the entirety of the process to maintain the nature of that triggering date in secrecy. That just can't be the rule, and I don't believe that's analogous to what occurred in Trinidad either. But is that the best we can do in your view?
I would say a couple of things. First of all, this is not a case where there's the employer somehow can secretly think you're terminated but never communicated to anybody and consequently deliberately evade any potential liability. This is a case in which letters were sent, they were attached to the plaintiff's complaint, they were very clear about what they wanted to happen. Those letters were embodying a decision on each of the employers, and it seems to me that clearly has to be the wrongful act, and that's what the plaintiff
just as
alleged.
we told opposing counsel, we're asking hypotheticals, and
right.
Among those next 100 cases, I hypothecate that there'll be one in which that letter is not sent, it's just filed in the top drawer of the chief executive's office.
Okay.
And
what's the event? Is it just it's really just the writing of the letter? That's your best answer for us? What's your second best answer? How about that?
It's the termination. It's the termination. So if I write a letter,
so it's when the letter
and I
is
never
communicated
mail the letter, I never do anything with the letter,
right.
But the letter has operative effect as it did here.
So in this case, was it him getting the letter on March 31st or not being allowed to go to Imlay City on March 31st? That's the triggering event.
He never worked in the city after the 27th. He never worked in the township after the 31st.
But on the 31st, he thought he was going to go, and then he was told not to,
and
right?
he was told not to
Right.
because
So is that
on
the event,
Friday he had been terminated from working in those
You're resisting our
areas.
question. We just want to know you're smart. Come on, help us.
I'm trying my best here. The letter, and On Friday, he was effectively discharged.
But he didn't know that.
On the
If he was
27th.
a salaried employee and the letter stopped him from receiving salary and benefits, you
Well,
might have a
that
point.
brings me to
You might have a point,
another.
but since he wasn't, and he would only be paid presumably when he showed up to work, I'm really having a hard time understanding what the adverse employment action was until the very next time he expected to go to work and then be paid and was told he couldn't be.
I guess I'm thinking of these med mal cases where there's an injury to the plaintiff, but they don't learn about it until some point in time. And I think our case law says the occurrence is when they were in the doctor's office and received the injury. I think.
When they got the information?
Not when they got the information, but when it actually happened.
Oh, when it happened.
But how do you, but going back to that analogy, which is a good analogy, how do you know when that happened? Like, how do I know?
The date that you were in the doctor's office.
But I don't.
We can do this later.
Oh,
yes.
okay.
Anything
Yeah.
else?
No, I mean,
Well-
I'm still a little confused as to. I'm just trying to think of this from a commonsensical perspective. And common sense, how am I supposed to, if I'm the individual being terminated, how can I be responsible for a letter that I never saw or know anything about? I just don't know how to apply just kind of a common sense doctrine to this.
It is a very common sense doctrine because
Okay.
it focuses on the employer's wrongful act.
But
just
I don't
as the
know, but
med-mal
if I have-
cases
okay, and I hear
focus
that.
on the doctor's wrongful act.
No, and I get that. I understand. I understand philosophically what you're saying, but if I'm like a prospective plaintiff, I don't know if this is happening. So if I don't know that this is happening, how am I supposed to take any action whatsoever if I'm not aware of the conduct that's taking place that's going to affect me?
Let me
That's
go
the
back to my question as a
legislative
friendly
policy
amendment.
choice.
Let me go
Well,
back
okay, I'll let you.
to my, this follows up on what Justice Bernstein said and what I said before being interrupted, which is we're talking about an occurrence in the employment setting. The statute reads in a way that we think of adverse employment actions. If someone's a salaried employee and they're terminated even without them knowing, but they're deprived of salary or benefits, then something adverse has happened to that person. But if a person, if nothing, that's not the situation we have here. And so I'm wondering, just by writing the letter, how that can be considered an adverse employment action when even until that decision to terminate or to retaliate or do whatever else we would look to as actionable under the statute, before that decision has been executed, how can that be considered an adverse employment action?
Well,
How does that make any sense?
That raises a whole host of questions about other issues about this claim, and the parties brought an early motion under the statute because it's very clear, based on the plaintiff's complaint and based on the letters, that there's no wrongful action that any employer did after the 27th. Consequently, that has to be the cutoff. This case is not the best vehicle for the court to write a decision in because there are issues about whether this was an adverse action. There are issues about whether there's no concession in this record, contrary to sister counsel's assertion, that these are alter egos. The Court of Appeals assumed, based on the plaintiff's complaint and allegations, that if they were, then the last date would be the 27th. If they're each looked at individually, there are a whole host of other questions, and these are somewhat atypical facts.
Counsel, is it my
because of
job?
that.
Is it my job as like an employee then to every day go to work and ask my employer if they're writing a letter of termination? Is that my responsibility now? Like, do I have to do that? So if I'm working for someone, should I go every day and just say, I just want to know, is there a letter being written for my termination? And ask them every day that.
For today, no, Richard.
But today I'm okay. But like
Ask us again
tomorrow,
tomorrow.
should I ask the chief if there's a letter he's writing for my termination? Like, and I should do it every day just to make sure that there's no letter being written I'm not aware of.
Let me respond to that in two ways. First of all, one is, yes.
I should do that every day.
There's
Chief,
nothing
are you
in the
writing a letter?
legislature that says that you have to know about an occurrence. But let me also say that's the same rule in all of these insurance policies that use this word and that don't require notice and that have very short notice provisions. And in the med-mal cases that Justice Wilder mentioned, you could say, well, do I have to go and have a third opinion every time I've had a treatment so I don't blow my med-mal claim?
What if I have
so.
one question. What if I send a blanket email to my employer saying, if I'm being terminated, can you please send me a letter to let me know that I'm being terminated? And if they don't send me that letter, can I assume that they're not sending me that letter?
I think what you're raising is the inherent harshness of a statute of limitations based on the
Well, no, I'd just like to know
occurrence.
the answer to the question. Actually, I'd actually like to know, can I do that? Under your analysis, can I send a letter to my employer that says, unless I hear differently from you, I will assume that there is no letter being written for my termination. And thus, if they don't send me a letter, my understanding is that no letter is being written. Can I do that and then be safe under your argument?
No.
I couldn't. So I can't even ask if there's a letter being written.
No, because the legislature has set this absolute cutoff, and I recognize that it can, in some circumstances, have harsh results. This is not that case, of course, as I think the questions have alluded, and I know you're looking at the broader case. This is not a case where the employee found out after the statute had run. There was plenty of time to timely file. Within that window. And so we would urge the court to deny leaving the lower court rulings to stand or to peremptorily affirm.
Thank you, counsel. Thank you, Ms. Klippel. Thank you, Ms. Ross. We stand adjourned until December.